Okay, welcome to sunny day. Seems to be changing from cold to hot all day. Let's have a look at something that I think you all need to address. And I think all of this trying to be better than everybody is stopping you from actually looking at the responsibility you have for your own country. Now, if people in command were committing international criminal offences, don't you have an obligation to do something about it on behalf of your country? Your country, not you, not the people around you, the whole entire population as a people. Don't you have an obligation to step forward and speak of those crimes that have been taking place? Now, a couple of people have been working on these sorts of things, and I'm just going to run through a document that was sent back to me. I'm not going to discuss who wrote the document, but we're going to look at the inabilities that are demonstrated in the first. Now, this is obviously a learning exercise, and who we've been working with has obviously advanced past this to be able to define things on a document, and that's what we want to discuss. How do you charge these people? How do you inform the state that a crime is taking place? How do you impress upon the Australian Federal Police that they have an obligation to act, to investigate these crimes? What sorts of things can you rely on as evidence of their requirement to act? And one of those things is the Brereton report, which very clearly defines that this government, the Australian government, has an obligation in its courts to hear all war crimes that are put in front of it. And this is the reason why the Australian Federal Police created this report a war crime page. It's not to report a war crime against someone in a foreign land. It's to report against this administration that has been managing the country under peacekeeping for the last 75 years. See, you have this opportunity to put together their criminal actions and report them to the Australian Federal Police. And anybody operating under that St Edward's Crown while in 75 years mode of peacekeeping could be defined as being in a line of authority that has committed some sort of offence. And the Queen warned everyone that you should know them by their rainbows. But at the same time, those rainbows opened up the door to all the change that you're seeing around the world right now, and that manipulated peacekeeping coming to an end. Everyone's speaking very openly about what happened 76 years ago, what happened over the last 50 to 60 years. It's starting to become very apparent as the witches fly around the cauldron, all accusing each other, while all of these rules that they become ignorant of lie underneath. And this will bring a certain state back to its blue, green, and then possibly no lines at all if it's not careful. The international community doesn't see it as a legitimate state, given that it's mandatory Palestine. And this is what we already discussed in a previous video. What is mandatory Palestine? How did your Anzac become involved in what became mandatory Palestine, and why? And the simple answer is this: the Ottomans stole your children and kept them as slaves, real slaves. So when we talk about all of these reparations for slavery, who's going to put the reparations on the table for the British Empire, which the Ottomans stole the children of? So this mandatory Palestine came about because of some evil that existed. And then it was collapsed into British Palestine, and the government of Palestine was created. All right, so I don't want to spend too much time on this, but we can see the start of a document here, and it's reasonably correct. We start to look at what a statement of claim is, and we realise it's not very nice to be charged by the police. That puts you on the back foot. To be on the front foot would mean to put your own claims before a court, or, in our case, report some sort of crime to the Australian Federal Police. But if we do it in the format of the Uniform Civil Procedure Rules, it sets you up by the mind to be able to defend yourself and make civil claims against agents that may have wronged you. This might be able to allow you to claim for damages, for instance, financial and otherwise. So we can see here that it immediately becomes convoluted in that too much in one statement. And the advice here is to break things down. So we can see that there is a claim against the respondent given the following. So we use the word defendant instead of respondent because the plaintiff is making an accusation which needs to be defended. But we need to look at how we split this up. So what I'm going to do is switch over to a Word document, and we'll actively look at this as we run through a simplified version of how you can put together a claim to go to the district or Supreme Courts and make a claim against anybody that works for the government or anybody else for that matter. So as we move forward, we can transfer these points here that are written as statements into more succinct claims that can't be obfuscated from their core factual belief. So we start to see all of these connections in international law while we define our sovereignty in the League of Nations. And all of these things add together to your ability to use the criminal code against those in that administration who continually commit crimes against humanity, crimes against their captives, crimes against the international humanitarian law, crimes against case law like the Nuremberg trials. And we discussed the poison chalice that they put to their own lips. And this is the time that you have to be able to point out the poison that they sipped. This is your opportunity to step forward and go through your own documents and submit them to the Australian Federal Police. We can then look at the Attorney General's office, which then has claims against the Commonwealth in relation to failure of trust, a failure of trust. So it is the Australian government that has been manipulated and has failed all of you. And you have the ability now to report the crimes of the state and the Commonwealth. This means every police officer that ever pulled you over and treated you like shit, smashed your window, pushed you around, tried to raise money through your name. These are all criminal offences that you can report as war crimes to the Australian Federal Police. They are aiding and abetting this peacekeeping force that is currently committing genocide on a world stage. They are aiding and abetting. This in itself is a criminal offence and needs to be reported to the Australian Federal Police. These are outside powers that people are in cahoots with, bringing all of these rules onto the table. So we should turn to a microphone and run through the process of making a civil claim, but using that process to report to the Australian Federal Police. This sets you up on 2 feet to be able to walk into a civil court and make a claim for damages against that officer or agent. This also allows you to then report to the Australian Federal Police, which will open up the door to a criminal offence. Criminal offences are charges of guilt for actions committed by people, whereas civil claims are for those damages. And those damages should be brought forward before all courts so that these players that manipulate your money markets are left paying those damages.
So I just recorded all of that and no sound came out. So we're going to do it all over again. So we looked at this document and we can see that most of it is correct, but we change it just a slight little bit here because there's a couple of things that don't need to be there, but they indicate what you're doing. So if we look at this document that I've put together, it says Supreme Court of Queensland, Supreme Court of New South Wales, Supreme Court of Victoria, District Court of. This will be relative to your claim. Claims of higher damages will end up in the Supreme Court, whereas lower damages will usually be heard by the District Court. Now, the first thing on the right should be these 3 details here. The date, so we put today's date in. The registry, so this is the local registry that you're at. Brisbane Supreme Court, Sydney Supreme Court, Melbourne Supreme Court. And then when you file, they will give you a number. And this is the number that you will use throughout the rest of your documentation because it relates to the filing that you've made for these damages. Now, we can see by the previous slide that it is this claimant and respondent. We're looking at something that is criminal in nature that will be used later for criminal action. So we will call ourselves the plaintiff, and then we will call the accused the defendant, because they have to defend their actions within this claim. So I'm using the title Joe Blogs because when I made a claim to the High Court in relation to Section 44, they took my pseudonym off my Google account instead of actually looking at the email that was sent to them. So as yourself, you and the rest of us, the people, use the words united in a federal commonwealth as defined in the engineer's case, 1920, which allow us united as people to make claims of a higher status under the blessing of Almighty God against agents or public servants within that estate. So we start off with these simple details. They define where and when. They define who you are and who you're accusing. They define some sort of standing as a united people, because the more of these that they see, the more they will realize that you're all standing in the same capacity here as people of that federal commonwealth. Now, we come down and we start to make a claim. Now, this is a simple cover letter. It's just a simple claim. This is to allow the justice to see what you're making a claim for or about without having to go into all the details. This will then be signed by the court and dated, which will then signify that you've made this claim through that Supreme Court, which then, when served on the defendant, defines to the defendant that you've made something in a legal capacity against them. So we can see here the plaintiff claims damages. Now, it doesn't have to be a monetary relief that you're looking for. It could be rebuilding of something that was damaged. It could be the giving you something new after something was lost or stolen. It doesn't have to be a financial claim for your damages, but here we put down $1 million. We also have to look at what is reasonable and unreasonable. So this could be looked at as a police officer using an unreasonable amount of force to fulfill his duty. The same could be said of you when making a claim, that if you make an unreasonable claim, you could be laughed at for making that claim. So it's in your best interests to make a claim that is reasonable in monetary value or in the recompense that you're looking for. This then starts to state that you rely on something else to make this claim, and this becomes the next document, which will list all of the details of the actions and the relative crimes that have occurred throughout your claim. So we may look at more than one crime over a course of time, which would then allow you to break that down and define specific actions to specific criminal offences. So we've set this cover letter up, and now we can address the defendant, because you're going to now serve this on the defendant. And we can see as we scroll down a bit, to the defendant, take notice that you are being sued by the plaintiff in a court. If you intend to dispute this claim or wish to raise any counterclaim against the plaintiff, you must, within 28 days of the service of this claim, file a notice of intention to defend in this registry. If you do not comply with this requirement, judgment may be given against you for the relief claimed and costs without further notice to you. The notice should be in Form 7 to the Uniform Civil Procedure Rules. You must serve a sealed copy of it at the plaintiff's address for service, shown in this claim, as soon as possible. So you're giving the defendant the heads up on what he's required to do, or she is required to do, to respond to your claim, which is now filed in a courtroom. If you assert that this court does not have jurisdiction in this matter, or assert any irregularity, you must file a conditional notice of intention to defend in Form 7 under Rule 144 and apply for an order under Rule 16 within 14 days of filing that notice. So you're giving options here on a way for this defendant to respond to this claim, and you have a legal obligation to inform the defendant of their rights in response. So it's in your best interest to put this at the bottom of your cover letter or claim, right? When we come down to the plaintiff relies on cross-vesting laws in respect of each claim, not the total claim, each particular point in the claim. Cross-vesting allows you to bring another jurisdiction into the matter. Now, this might involve something simple like workplace health and relations, OH&S, and that's a different set of laws that may come into this court, which is a civil claim. Cross-vesting laws also allow you to jump up the tree from this district court into a federal jurisdiction, or eventually the High Court, if you can argue some sort of constitutional matter in the case. So putting all of this together and informing the defendant of their obligations. You're obligated to give details where that defendant can serve paperwork back at you or contact you. This is also relevant to the court, who may send out paperwork to you or contact you. And then you sign or seal this document before the court so that the court can see that you are stating your true facts in the matter, and then you're providing the defendant's residence and address for service to the court, because upon service of this document, the court's going to start this TikTok timer. There's 28 days to respond. And this is very, very strict in that on that 29th day, you could lose out. So advising the defendant in the first of his obligations puts all of that to the side, in that it's not an excuse if they're in 1 day or 2 days late. So we look at this claim. We've got our cover letter. We've put in a claim for damages. We've relied on an attached statement of claim. The court would then authorize this claim and sign and seal it. You would then serve it on the defendant, who had 28 days to respond or 14 days to respond in certain circumstances. And then we come down to your statement of claim. And this is where you will actually define the things that you're making an accusation of. So as before, it's a new document now, but it has the same details on it as before. So the date, the registry of the court that you filed in, the number that you're given by the court, and the details here of the plaintiff and the defendant. This should reflect the same as the top here. So if we copy that and bring that down, we can basically put the same thing here and then start some form of statement of claim. Now, when we looked at the previous document, we could see that the statements were made in sentences. And this allows someone to skip over a specific fact because it's bundled with other facts. So it's in our best interests here to define things in their singularities, because then when you refer to a number here in this list in your claim, only one thing is relevant to that number, not multiple things. It leaves obfuscation of anything out because you're defining it yourself. And then it's an inexcusable fact unless it's rebutted. And then they can be rebutted point for point. So in our first document, we could see that we defined the defendant. At all material times, the defendant was a holder of office title of the department or agency where that office is, and B, did hold some sort of command responsibility in office of that office title. So did hold command responsibility as police commissioner of the Victorian Police Force, Shane Patton, for instance. So you're tying them very specifically to a duty, office, an obligation, and you're defining who they are while in that role. 2, at all material times, the defendant, yourself, was united in a federal commonwealth, the Engineers case 1920, and did have a right of self-determination, the ICCPR Article 1. So when we look at this, we're being specific, but not specific enough. And this is where our claim will become specific. We'll get into that next. But here we start to now list any of the things that the plaintiff or the defendant. Sorry, this should read, no, that should read defendant, and this should read plaintiff. So at all material times you were, and at all material times the accused was. And then we start to detail step by step every action that could possibly have created a criminal offence in individual numbers, bullet points. So we could say here that the defendant did assault the plaintiff by striking the plaintiff to the right cheek, going against the Criminal Code 1995 at section, not sure what section it is for assault off the top of my head, but we would look through the criminal code and we would define that specific action, and then you would then repeat this statement for every action that occurred, bundling up a whole bunch of actions and relating them to the actual crimes that were committed. So here we have the responsible party, the victim, the action against the victim, the criminal offence that occurred by doing that action, and then we could go into more detail by defining at a place, at a time. And then you start to build a timeline of events that occurred, especially if these things occur over weeks, months, years. We can now start to build up a picture of all of the actions of the accused to see if we can come to the conclusion that some sort of remedy, or as we put up the top before, some relief, some damages here for 1 million, right? And as we go through this, we can see then, after our numbered list of all of our actions and our criminal code 1995 or criminal code 1900 or Crimes Act 1900, depending on each state, just pull all the laws that you find together and make accusations of and define those actions by the accused to an action, to a time, to a place, to a criminal offence. Each one of those things then has to be rebutted by the accused, the defendant. The defendant would have to say here that he did not strike, or he was not at that place, or it wasn't at that time. There are things now that would need to be rebutted over one specific point here that we've discussed. What if there are 50 or 100 points here defining every specific thing relative to a criminal offence? Then we come to close off our statement of claim by just bullet pointing the plaintiff claims the following relief. Damages, little spelling mistake there too. So damages for assault and common assault, damages for trespass, damages for delaying due process and justice, damages for failure of a duty of care. You could add other rounded accusations here that deserve damages, but here we kind of look at the core basis of the law that will give a justice a right to define everything above as some sort of crime. So this comes down to bringing the core ideology of all the law above to this total action. It was assault and common assault, Your Honour. He did trespass on the property, Your Honour. He did delay due process by not providing the paperwork required, Your Honour. He did fail in his duty of care, Your Honour. These are then able to be looked at for the very specific points above that would lead to your belief that these things were true and then would require said damages. Now, you obviously sign and date this, and then another notice as to defense. To the defendant, your defense must be attached to your notice of intention to defend. So if the accused wishes to defend, not only does he have to file in court that he intends to defend, he has to provide some sort of defense that can then be scrutinized by you and rebutted on the return. And then this starts the tennis match of what is a crime by words to get to some sort of result of damages through those words. So now we speak of taking this document, which is ready for you to walk into any district or Supreme Court and make a claim. Read through the Uniform Civil Procedure Rules as to the rules of your claim. This will define what we've just laid out here. If you want to display exhibits or attachments, they're called exhibits because you're going to present them to the court. And these could be photographs, these could be documents, these could be a bunch of different types of things, including audio or video. And these things will be presented to a court. These go in a separate document in a numbered list called an exhibits document. And that again needs its cover letter defining what's in the list of exhibits. And then you would number each one of your exhibit so that when you refer to these exhibits in real life, that tape recording might have a number and that document might be will have a number 3. That photo will be number 4. And then when you look at this list, you can see the description of that item that's presented to the court. So a lawyer can now look at this exhibit list and there's a description of that numbered item that's presented to the court. So when we file to a court, that allows us to now make a solid claim. And all of you should be aware of how to do that and teach each other more about making civil claims against police officers, council, state, federal, because this applies under uniform civil procedure rules. And everyone has to play by the same set of rules. Scott Morrison defined it as rule of law. Model law has the force of law. So now we can take this second document, the statement of claim in its single document, and we can now use this document to make a report of a war crime to the Australian Federal Police. So if we lay this out in the very same format that is the Uniform Civil Procedure Rules, we can see that we could change the title Supreme Court of State into the Australian Federal Police Complaint. We could change the registry to the Australian Federal Police Online. We date it. We define the numbers that are attached to this complaint over time. We put ourselves as the plaintiff. We put the accused as the defendant. And then we detail a statement of claim that states for every action there is a criminal offence, and we could go through every action, 40, 50, 60 different actions in one document that then build up to demonstrate not only multiple criminal offences that are occurring, but a culture or a picture of that occurring constantly or over time. And this is especially important if these events happen over hours, days, weeks, months, years. This correlation of a timeline of events helps paint the picture that the defendant or the accused does the actions within the document regularly. This would then indicate some sort of modus operandi in the mind of the accused to continue to act that way.
Okay, now I've been doing this for 20 plus years. So all of you that keep playing this fine game, I want to demonstrate something to you, but at the same time I'm telling you not to copy what I've done without having some understanding of all of these things that precede it. Like how to run an estate, what one is, how the Bible works, what that claim actually means, how it is divine, what makes it what it is, what the blessing of Almighty God is. There's so many things to go on with here. The knowledge is just vast. So I'm not putting this up here for you to copy. Like, I'm not asking you to copy. You should be making complaints that these people have committed the criminal offences that have occurred. And then as you speak united as a people, that strength might come forward for all of you. So what we're about to discuss here is mainly aimed at those that are listening, to demonstrate that, yes, I have been doing this a long time, and yes, there are things that might be outside of your mind scope that we look at, because we have Justice Lonergan in the Supreme Court of New South Wales making statements, very, very, very clear statements, and they're relative to things that were filed in the Supreme Court while David Halpin was sitting at the bench in the Magistrates Court. Because I went through this process up the chain to go back down the chain to see how David Halpin would react. And he chose to react by committing a serious criminal offence instead of recognising what someone in that district court was saying to him. He failed to recognise it, and in his old greying-haired age might start to fear it, because this was a reality put on the table that has brought a lot of people to listen. So I'm asking all of you to be aware that this is not a path for you to copy. It's something for you to wake up to and slowly build into and learn over years to become yourself. It's not something you can rush into a courtroom tomorrow and think that is your fix. But we demonstrate to all of you over the last 15 plus years the things that have been established on the courtroom record. And we're just going to jump through a few things, just like skipping across the top, because we're not really going to go into depth about what all these things mean. It might just be an indication to those that are listening that there is a bigger thing on the table.
Now, a long time ago, I was walking through the back alleys of Nimbin, and I saw a police officer abusing a young fella, a teenager. The guy was about 17 years old. And this guy had all his stuff laid out on the floor, and these two officers were powering over and above him. And he was almost in tears the way that they were intimidating him, causing him a whole bunch of anxiety. So I pulled up and I said, "You can't treat them like that." And I stood there and watched and tried to get them to clean their act up, and didn't involve myself in any sort of arrest. But one of the officers grabbed me and threw me in the back of a paddy wagon, only to drag me back out again because he'd thrown me in there with all my belongings on me, and then post fact decided that he was going to charge me. Dragged me all the way down to the police station, went through this entire rigmarole where he decided he wasn't going to charge me, and ended up issuing me with this notice to appear or attend court. Now, no formal process of charge has been taken place. This is a notice asking some sort of person to attend the court. And this is where the scam begins, because these police have been given this carte blanche ability to rape you for financial burdens in the matter. And we can see this by this ongoing roundabout of money collecting that goes on by the state and its police forces. It's called slavery, and it's been pointed out to all of you. Now, the police are disrespectful. Everybody's getting a grasp on that. So there's this document open for you to all look at. They dragged me down to a police station because I stood there and watched Taranto abuse a child. 17-year-old is a grown-up, but he's still a child, still a minor, he's still under 18. And they had this guy's belongings all over the floor around him. Well, they almost pushed him into tears. So when I got to the police station, I was in this modus operandi of, what the hell are you doing? So I just let them play the game and step through their processes. But you can see here by the statement by Taranto, it would appear Spiers, by his own admissions, wanted to be arrested to test his sovereign ideology in court. The gaslighting that these people do is incredulous. You dragged me into a police station at which you expected me to play along. You expected me to play along after you committed an offence. And I stood there and watched you commit that offence. And you turned it into me wanting to be arrested, when the fact of the matter is that I acted that way after you arrested me. The sovereign citizen ideology came to be a reality. We saw the man that we will mention very soon appear on the TV not long afterwards, trying to push that propaganda all across Australia. So we move forward and we see a second statement. The accused told us that he had only done what he had done to test it in court. Well, of course I was going to test it in court when you did what you did. And that's the sheer fact of the matter. And what we can see here is this future CAD master cover sheet. Now, I ended up with this because I was presenting myself in court, and this can be shown by representative self. So there were two occasions where no representation had occurred. All three occasions are signed off by Magistrate David Halpin. There he is, listed as the signatory to the offence that was committed here, because there's an accusation that I posted things from a courtroom on social media. But that actually didn't occur. That didn't occur at all. What was left on the media was the arrest that occurred on the roadside some time before, knowing that you would confiscate said media only to watch yourselves on the roadside. But here we have a courtroom document that mostly magistrates get to see, because this is David Halpin signing off on him sitting in these appearances. Now, I had done some things in the Northern Territory, and I brought those things forward and had them re-stamped by the Department of Public Prosecutions in Lismore. And this then ended up on the courtroom record before David Halpin. And if we look at this document, be it known that I, of Darwin, Northern Territory, in the United Kingdom of Great Britain and Ireland, is authorised as follows to act for the Crown, Her Majesty Elizabeth II, lawful sovereign of Australia at the time, in respect of all offences complained of or becoming known to him in his capacity as Commonwealth public official by the authority of the below reproduced acts. Now, this is a statement that says I know the Commonwealth and I'm willing to stand by this legislation as defined below, and I'm willing to stand here and make an accusation to you that you're outside of the Constitution. So I filed documents with the Lismore local court, which sat before David Halpin, notice of mistake, coram non judice, without jurisdiction, it means, a matter of public interest, for and on the record. It seems that an at the time unidentifiable man claiming to be an alleged police officer under the employ of the New South Wales Police Force ABN 43408613180 under Corporations, Fair Trading and Accountability legislation of Lismore Police Station, bearing false witness in his claim that a bond servant of the Creator through Christ was in fact an artificial person, construct, nom de guerre, capitis dominitio of either Commonwealth of Australia, New South Wales Government, Magistrates Court of New South Wales Police Force, or State Debt Recovery Office corporations registered under Securities Exchange. All of those assumptions are denied in their entirety, and you are reminded of the law of your master as required of me by my master in all presumptions of jurisdiction over the living soul bondservant of the Creator through his Son the Christ, his wife and heirs, is denied, and I am witness to attempts to joinder a living soul to a dead legal fiction. I am that I am, and I bear witness to trickery and false witness, fraud and theft, and presumptions, assumptions of your state, corporation, being perpetrated by various man, woman, acting as presumed, assumed, authority, legal, fiction of law. I come in peace to make all parties whole and for peace to reign. I request I be shown where I was consulted and agreed to arbitration in this matter and who holds the documents under usufruct. I wish to end hostilities as I am not an enemy, hostile or belligerent, and require armistice agreement from occupying powers and do not consent to slavery imposed under usufruct by the use of the Certificate of Citizenship. I wish to assist the Commonwealth of Australia from a neutral standpoint and to make all parties whole for peace to reign. I therefore accept for honour any and all financial instruments on behalf of the Commonwealth of Australia and make them payable to the Commonwealth of Australia Treasury.
So the funny thing here is they accused me of putting things online that I did not. And now, full circle, it comes around to bite them in the ass online. I'm pointing out here that these things have been done 2015. That's a decade ago. A decade ago. And there are things that you're doing right now that don't even correlate closely to being a grown-up in respect of them guardianing you, treating you like the children, treating you this way and keeping you this way so that they can enslave you for financial gain. More concrete for Queensland, more concrete for Australia, so that the silver spoon keeps cycling around in your poverty. And this worldwide game is a bunch of really heinous, evil men trying to keep that status quo going. And I'm asking all of you not to go down this route, because I've shown you that you can make accusations and slowly grow up into realizing how they've manipulated you, but you're not running into a courtroom straight off the top proclaiming to be all of these things when they can make accusations of a delusion against you when you fail to know things. Because a justice said to me once that when you say one thing wrong, it makes everything you say wrong. And this made me go back and double look at a whole lot of stuff that I had done, trying to figure out what that one thing that I had done wrong was. And slowly over time, we've left things to the wayside for the sheer fact that these people have walked into a serious criminal offence, literally giving us the authority, united in a federal commonwealth, to make accusations against what is an administration here and see it culpable to things like the Brereton report themselves, all across the country. Down to the police officer driving around in your local suburb, down to every single agent working for the state that could have taken a financial gain or used their power to their own advantage, all across the country, all across the country, all the way up into all the federal and state parliaments and all the decisions that these ministers made on behalf of something very, very evil and criminal at law. And these next documents I'm going to show you sort of indicate something that you're being mind manipulated away from, that they refuse to acknowledge, because they believe that with their war crimes they can still enforce model law. They can still enforce some sort of law here after disregarding it themselves, which puts them in a really tenable position, being the ones that are the offenders, the war criminals that created these crimes in the first place. And we can see that by this can sheet, that they're signatory and they're on documents, and they are wholly liable for all of those decisions that have been recorded.
Interestingly enough, Christ said, "Let the dead bury the dead." So one might have to prove that one was alive and not lost at Holy See, per se, under this Sesta QV Act 1707, where someone else had taken the estate without authority to take said estate because some sort of salvage had occurred. But I actually went to a doctor and had a doctor sign a legal document. There's actually a legal document that I discovered and printed out and filled in, and had a doctor go and sign it. And it's very relative to being live born versus birthed in respect of this estate. Right, so we can see that my mother and father are detailed, and my two sons are detailed, and we can see that it's biological. and they are my parents, and I was then alive, and the firstborn son of my father, and first fruits of my mother's womb, and entitled to my birthrights as such. My nativity was recorded in an uncopyrighted version as an abstract of my nativity, being born alive, freeborn, a child of God, the Creator. So you can see this sort of starting to actually make a claim here against something that keeps you as a dead legal fiction. And we heard Penny Wong use those words in a previous video. What do you mean? The legal fiction? Now, part of this claim here wasn't really for personal gain. We're here defining life over death and administration over what they administer. And we can here see that notice of appointment to the Steward Executor's office from the Office of the Steward Executor Spiers Stephen Estate to any and all persons, officials and officers in any capacity that may believe they have authority to administer or have any interest in the estate of Spiers Stephen. Subject, grantor and heir assertion of right and acceptance to the office of Steward, Executor and Administrator for the estate of Spiers Stephen. Situation and purpose, to confirm by acknowledgement the appointment of the man referred to as Spiers Stephen to the stewardship with full authority as occupant of the office of the General Executor, Chief Administrator, Guardian of the estate, and ship's master for any trust and all matters governing the estate of Spiers. Let it be known to all that by this duly recorded notice that the stewardship for the Spiers Stephen estate is hereby occupied, nunc pro tunc. This goes on to link God and the office of God through his will into this inalienable freedom and liberty over our free will, our flesh, our energy, our labor, our minds, our time, and our divine spirit. This triune authority with the Son, the Father, and the Holy Spirit, dominion from the divine Creator, right, do pronounce, claim, and occupy said office. And this was done 2015. So we start to look at a document that lays out some sort of administration of one's own affairs rather than allowing the state to take that will, that free will from you. And this is something you can't do overnight. This is something that you need to learn with God. Notice to the trustees and fiduciaries. Trustees and fiduciaries may not assert any management power over the estate without delegation in writing by authority from this office. Fiduciaries shall at no time improperly use the estate money, assets, property, services, credit, or interests in the performance of or as a result of their official duties for activities that have not been approved by this office. And this puts this state that is supposed to be in guardianship over something in a command responsibility over that thing, the estate or the child that hasn't grown up to become or manage that estate. And while they use that estate for their own gain, they treat you dumber and dumber and dumber so that you never learn how to be this office of your own estate. Public officials wishing to present a claim against the estate shall, in accordance with the law and administrative policy established by this office, comply with the requirement to disclose personal assets and liabilities, as well as those of their spouses and or dependents, to the administration of office of the estate. This is putting your liability forward as a public official if you wish to interact with said estate. And here we can see the District Court of New South Wales and the Office of the Director of Public Prosecutions has stamped all of these documents, therefore acknowledging the receipt of this life claim. And it is a life claim because you're now returning to the estate of your father rather than being warded to the state like Oliver. Please, sir, can I have some more? How about, sir, you get out of my father's house? And that be the sum of it. And this leads us to this one last point. Redemption, a repurchase, a buying back, the act of a vendor of a property in buying it back again from the purchaser. So redemption in usufruct might mean not getting into debt. And I've never used this credit system in my entirety of living, so would not need to redeem something that may have been taken from me.
So now that you've looked at some sort of life claim to live in some sort of estate instead of being guardianed by the state, might give you the mental power to see what united in a federal commonwealth actually means and what guardianship and dependency, Oliver, please, yeah, can I have some more, actually means to the orphan who had their father die in battle and not return home, only to have Robert Menzies go and sign you up into some monster machine and move in as your guardian, as your guardian. And this is the harsh reality. So as we look at state guardianship, we look at a criminal offence for keeping you there. Because under the Hague Conventions, Article 43, I'll pull it up on screen, I'm pretty sure it's 43, everyone has a right to religion and everyone has a right of family. A right of family. Now we could look at you, David Halpin, and what you did in offence of the family at rule of law. Rule of law, rule of law, rule of law. So we start to comprehend now that this is bigger than your mind was awake to, and we've made some sort of claim here to a blessing from Almighty God that has been defined on the courtroom record, sealed by that court stamp up in the corner. So this is relevant to Justice Lonergan already knowing things because this is her courtroom, isn't it? So today we looked at how to report a crime and where to report it and how to put that paperwork together and how to be more specific about the claim that you are making to the Australian Federal Police. The more information you put down in relation to a criminal offence, including the criminal code that has been breached, the Australian Federal Police will be left with little room to wiggle in the decision making of the crimes that have been committed. They will have been pointed out very clearly by all of you. If you wish, you could then walk into the District or Supreme Court and put down the funds to start a civil claim against the agents that have instead breached against you, breached international law, breached the Constitution, breached a blessing from Almighty God, breached the foundations of your forefathers, and instead worked in cahoots with foreign interests to your Constitution. So we hope you get busy and you start reporting everything all the time to the Australian Federal Police, and you do not let these things go, because it is in your power as a people to demonstrate that you are aware of this administration taking place on your lands, and you are pointing out the crimes that have taken place while in that administration. So until next time, think about how you can have an impact. Think about how you can make the change. Think about how you can put their names on the record and report their crimes and start the Australian Federal Police into an obligation that might draw in the military police.